There is a wealth of legislation and case law in Northern Ireland which addresses discrimination in the workplace. In Northern Ireland, the protected characteristics relating to discrimination in the workplace include age, disability, gender, including pregnancy and maternity or marriage and civil partnership status, religious belief or political opinion, sexual orientation, gender reassignment and race, and in particular in Northern Ireland, members of the traveller community are afforded specific protection under the race discrimination legislation. There are various types of discrimination which may be alleged by an employee or indeed a former employee, such as direct discrimination, indirect discrimination, harassment, victimisation, discrimination by perception or by association. Looking at direct discrimination then, direct discrimination is where A treats B less favourably than A would treat others, and that less favourable treatment is because of a protected characteristic. For example, the employer treats one employee less favourably than they would treat another person, and that different treatment is on the grounds of that employee's religious belief or political opinion. And subject to very limited exceptions, direct discrimination can never be objectively justified by an employer. Moving to indirect discrimination then, this would relate to a provision, criterion or practice which on the face of it is not intended to treat anyone less favourably. However, when it is applied, it has the effect of disadvantaging a group of people with a protected characteristic. And where such provision, criterion or practice disadvantages a group of employees with that protected characteristic, it will amount to indirect discrimination unless the employer can objectively justify that provision, criterion or practice. An example of indirect discrimination would be a requirement that an employee must work full-time with no objective justification or business reason for requiring such. This may be seen as being indirectly discriminatory against female employees, for example, who may have childcare responsibilities. Looking at harassment, the statutory definition of harassment is unwanted conduct by one person that is related to a protected characteristic which has the purpose or effect of violating another person's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for another person. And when addressing harassment, the tribunal will consider the perception of the person alleging that they were harassed or suffered from harassment and the reasonableness of that perception, rather than whether the behaviour was intentional or not, which should be kept in mind by employers when addressing humour or jokes within the workplace. Victimisation then would be where a person discriminates against another person if he treats the person victimised less favourably than in those circumstances he would treat another person, and does so by reason of a protected act. And those protected acts might be a complaint raised by that individual, or in fact proceedings being issued by that individual which allege discriminatory treatment under a protected characteristic, or indeed simply by that employee giving evidence or information to support another employee's complaint or claim at tribunal which relates to discriminatory treatment by the employer.